I want to start by saying it has been thrilling to co-author this paper with Stephanie, and I've learned so much. It's been so much fun to work together on this. Originalism is a two-step process, and I spend a lot of my time in step one looking through evidence of original meaning, and then step two has to do with application to current constitutional controversies, and Stephanie does both historical investigation and just has a brilliance in analysis of jurisprudence, and so it's been wonderful to work with Stephanie on the piece. We have had some disagreements, okay, and because she got the last shot at working with this draft and I wasn't paying attention, somehow my name got placed first. This is incorrect. But it remains a matter of intense negotiation. Okay. Now, to set the stage, we're talking about heightened scrutiny for laws, for generally applicable laws that have a significant impact on religious exercise. The big case here, of course, is Employment Division against Smith that denied, as a general matter, such heightened scrutiny. Scalia's opinion for the majority is obviously a non-originalist opinion. And my very first article as a law professor addressed this particular issue. And my research over the years that has just increasingly looked at the development of American understandings of liberties and the Bill of Rights prior to the 14th Amendment convinced me that I wanted to take another shot at it, especially because that first piece, as Larry Solom often reminded me at the time, completely lacked theory. I've tried to do, Larry, I don't know how I'm doing, but your voice rings in my ears. All the time. Just in terms of the general constitutional theory, we accept incorporation. We accept that as justified as a historical matter, so we don't get into that issue. And so instead of accepting incorporation, we're looking at what was the likely understanding of the public regarding the nature of free exercise of religion at the time of the ratification and framing of the 14th Amendment. The article starts with the quote from John Bingham in a speech in 1871. The quote post-dates ratification by a few years, but in the article we argue that it is representative of the Reconstruction era understanding of the free exercise of religion as protected by both the First and 14th Amendments. The drama that is presented in the history part of the paper basically looks at the struggle between the proponents of slavery and religiously motivated abolitionists, and how out of that struggle emerged a Northern Republican understanding of free exercise that, in fact, protects the right of believers to engage in basic acts of charity, even in the face of religiously neutral and generally applicable prohibitions. Exactly how that cashes out is going to be discussed by my colleague. The paper pays particular attention to two historical moments. It addresses a lot of history, but I think two key areas involve the Second Great Awakening and the rise of the religiously motivated social activism of the 1820s and 1830s, that then includes the rise of religiously motivated abolitionism, and also the flashpoint of the adoption of the Second Fugitive Slave Act in 1850, and the reaction to that in the North by Northern abolitionists to both federal and state attempts to criminalize the aiding of a runaway slave by providing shelter or even a cup of water or a crust of bread. Religious abolitionists and increasingly Republicans as a whole viewed such laws as basically forcing individuals to violate the commands of their Lord and Savior Jesus Christ, Christians believed, as declared in the Gospel of Matthew. And one sees, if you do a search during this period of time, you'll see references to the Bible, Matthew chapter 10 and Matthew chapter 25, all over the place in terms of political speeches and essays in newspapers, all of them talking about Christ's injunction to provide a crust of bread or a cup of water to the needy. And Harriet Beecher Stowe, of course, took that idea to the masses in her incredibly popular and influential book, Uncle Tom's Cabin, which I was thrilled to read for the first time in the preparation of this particular article. And I have to give special thanks to John McHale, because it was at the I'm pretty sure it was the Stanford conference. I think you were there, and we were talking about this idea. I was talking about the idea of religious resistance to the Fugitive Slave Act, and you said it's just like that chapter in Uncle Tom's Cabin, and the discussion between the husband and wife as to whether or not they should follow generally applicable law passed for the public good, or whether or not they should follow the injunctions of their Savior. It was brilliant. I had no idea at the time just how influential that particular chapter was, and the argument that she was setting out. She really brought mainstream the idea of justified religious resistance to the Fugitive Slave Act. Again, these references, I've used the reference to the crust of bread in the title because that's straight from Bingham's quote. But again, you can do a search. You can do a search for a cup of water, a crust of bread, and you'll find it in the political and religious and legal rhetoric of the time, as involving slowly but surely a broad understanding by the Republican Party that it was justified and a duty of Christian believers to go forward and resist these generally applicable laws. Now, if we hadn't had the 14th Amendment, this would be an interesting story of civil disobedience of one form or another. But we do get the 14th Amendment. And our argument in the paper is that it was informed by these ideas, a general acceptance of the legitimacy of religious resistance to laws that prohibited basic acts of charity. And you find this type of rhetoric prior to the Civil War in James Wilson in the debates over the 13th Amendment. And of course, you find it afterwards in that particular speech by John Bingham. And I just would like to quote this, because this passage was a mystery to me until I did research for this paper. And I'll just close with this. Here's Bingham, author of the Privileges or Immunities Clause of the 14th Amendment, in 1871 in a speech that is directly about the protections of the Privileges or Immunities Clause. Quote, before the 14th Amendment, a state, as in the case of the state of Illinois, could make it a crime punishable by fine and imprisonment for any citizen within her limits in obedience to the injunction of our divine master to help a slave who is ready to perish, to give him shelter or break with him his crust of bread, end quote. And that after the passage of the 14th Amendment, those kinds of laws, not the Southern slaveholding laws, he names Illinois, a northern state that was seeking to enforce the Fugitive Slave Act, as an example of the kinds of state laws that are no longer constitutional. So that's our basic history story. Now we get into the application.
Thank you, Kurt. Really briefly, thank you to Mike and to the conference organizers, to all of you for being the few, the proud, the originalists at the end of the day. I hope we can make it worth your time. And it's special for me getting to be up here in between Fred and Kurt, because Fred has long been a great friend and a mentor to me, without whom I would not have become a law professor. And it's also through Fred's classes that I first read Kurt's scholarship as a law student and became a huge fan. And so what an honor it is to now get to be sitting with Kurt and working with him when I've learned so much from him as well. So, and I also just briefly want to recognize and thank my son Case for being here with me. I see his phone died, which means he's actually going to have to pay attention to what I say. But this is how we train the rising generation of originalists, right? So, all right. One thing that I want to add to sort of the historical frame that we're looking at in terms of what's going on around this time with the Fugitive Slave Act is, although religious exercise is obviously really important, and there's a lot of great evidence in the paper that Kurt was talking about in that particular context, we're not trying to argue that there was a view that religious exercise was viewed as an unlimited right. In 1868, all 37 state constitutions protect religious exercise in some form or another. Nearly half of them, though, have an explicit public peace and safety exception to free exercise rights, suggesting that there's this understanding that while religious exercise is given significant protections, there are certain reasons which would allow government to limit someone's ability to exercise their religion. there's one case at this time period that at least suggests government attorneys understood this sort of permissible limit on religious exercise. This is the 1845 U.S. Supreme Court case of Promole versus Munn, and it's a case involving a request for a religious exemption for an ordinance preventing dead persons from being exposed so that certain religious rites could take place. And there, the government attorneys argued that the law of necessity would justify enforcing this ordinance anyway to prevent the spread of yellow fever. I think we all have been thinking more than we would like about religious exercise conflicts in the context of the pandemic, so it's interesting how relevant this is now. It was decided on other grounds, so there's not court reasoning to this effect, but the arguments that the attorneys are making sounds in the same vein as the type of exemptions that exist in these state constitutional clauses. So the argument that we explore in terms of what might the constitutional doctrine look like as a result of some of this historical evidence. First of all, we don't argue that, again, there's some sort of categorical or absolute right that was recognized or understood under the 14th Amendment to engage in acts of religious charity in the face of conflicts with neutral or generally applicable laws. I talked about some of the historical reasons why that's the case. I also think as a pragmatic matter, that would be a really unpalatable rule, probably, for the Supreme Court, which is one of multiple reasons why, if the Supreme Court overruled Smith, I don't think that's a rule it would adopt. It's hard to imagine the court saying that even if someone is doing something charitable, like a nursing home or an orphanage, that they're just not subject to government limitations or regulations about that. But we do argue that this sort of historical evidence is at least consistent with a strict scrutiny approach. We're not arguing that the historical evidence requires that doctrinal approach. That's an act of construction, as Larry has written about, trying to decide what constitutional doctrine is best going to implement the communicative content of the 14th Amendment and the public original understanding at the time. But strict scrutiny is a doctrine that asks whether or not government has an important reason for limiting religious exercise and then imposes evidentiary burdens on the government to demonstrate that its actions are necessary to advance that sort of important government interest. If Smith were supported by the historical evidence, then there wouldn't really be an objection to the Fugitive Slave Act because it's neutral. It's not aimed at religion facially. There's nothing to suggest that its enforcement is treating religion as the object of the Fugitive Slave Act enforcement. And it's generally applicable. There aren't exemptions to the act. It applies to all citizens. And it doesn't include a lot of mechanisms to provide for individualized exemptions under the act. So if Smith were the law and it was understood that that's all that free exercise protected, then when the 14th Amendment is ratified, nothing changes, nothing should change. And so then Bingham's quote doesn't make any sense. So at the very least, while we're saying strict scrutiny is a doctrine that seems consistent with the historical evidence, we are also arguing that Smith is a doctrine that is inconsistent with this historical evidence. I'll go ahead and pause there.
I appreciate the invitation to comment on Kurt and Stephanie's paper. I thank Stephanie for her gracious words, but if you know Stephanie, you know that her success in the Academy has been almost entirely her and not her mentors. I like them both and I respect their work. It always makes me think. And I enjoyed this paper. I learned a lot about abolitionism and 19th century Protestant understandings of religious exercise. There's actually two theses in this paper, I think. The first 2/3 of the paper demonstrates, I think, convincingly that abolitionists were outraged by the interference of fugitive slave acts with what they viewed as religious exercise. But then towards the end of the paper, it pivots from outrage, criticism, civil disobedience of the Fugitive Slave Acts to an argument that Bingham's reference to the Free Exercise Clause in his famous 1871 speech encompassed or or shows that he understood the Free Exercise Clause, now newly applied to the states, to encompass a presumptive right of exemption from the incidental burdens of generally applicable laws. And that's a very different claim than the claim in the first part of the paper. So I'm going to focus on the second one. I don't believe the argument succeeds because I don't think Kurt and Stephanie supply the evidence of original meaning that this thesis requires. Specifically, I think there are at least 3 places where evidence should be abundant and easy to find, evidence of original meaning, but none of it appears in the paper. So first, the excerpt that Kurt and Stephanie quote in the paper and that Kurt just quoted for you all here deals with a conviction for harboring a runaway slave under a state fugitive slave law. Bingham implies that had the Bill of Rights applied to the states in the 1850s, the defendant would have been immunized from prosecution because his assistance to the runaway would have been protected by the right of free exercise. Now, I think this counterfactual is implausible. The prohibitory language of the Federal Fugitive Slave Act of 1850 is nearly identical to the state act that Bingham referenced in his speech. Prosecutions under the Federal Act were subject to all federal defenses, including rights enumerated in the Bill of Rights, like the free exercise of religion. So there should have been federal fugitive cases in which the right of free exercise was raised as a defense. Now, Kurt has forgotten, Kurt has forgotten more about the history of the adoption of the 14th Amendment than I've ever known. So I can't say that the absence of citations in the paper means that they don't exist, but they don't cite any. And those should be easy to find. There were a lot of slave cases prior to the Civil War. Their absence suggests that the free exercise of religion was not understood to be a defense to prosecutions under the 1850 Federal Act. And if that's true, then there's no reason it would have been a defense to parallel state laws, even after it's applied to the states. Bingham, in short, may well have been mistaken. Now, secondly, this second thesis, Kurt and Stephanie's argument for this thesis rests on a questionable implication in a single speech by a single member of Congress delivered 3 years after the fact. So even if we concede, as is almost certainly the case, that this congressman was the most important framer of Section 1, that's pretty weak evidence of the original public meaning, how the public understood Section 1, or some significant subset of the public understood the newly applied free exercise right. Did others share Bingham's understanding of free exercise? So I made up a few of my own counterfactuals. If Slaughterhouse had come out differently, would courts have understood the free exercise of religion to immunize Christians or Jews who extended charity to escaped convicts, or other fugitives from justice, ordinary fugitives from justice? What about clerics who felt a religious obligation to solemnize interracial marriages? So similar claims by Mormon polygamists failed in the real world, not the counterfactual world, just 10 years after ratification, because polygamy violated conventional moral norms enforced routinely under the police power which Congress assumed in governing the territories. There's not a hint in Reynolds of any free exercise presumption that the government had to rebut before it could enforce the anti-bigamy laws against George Reynolds. What about a commitment to integrated education? Berea College was founded by Christian abolitionists in the 1850s. Now, after the Civil War, the Kentucky legislature left it alone until 1904, but had it ordered it to segregate earlier, say, in 1870, would the public or the courts in Kentucky have understood and incorporated free exercise right to stand in the way? Here, I'm not going to be, I guess, so humble about the history. All of those counterfactuals sound very, very implausible to me. Kurt and Stephanie don't supply any evidence that the original public meaning of free exercise in the late 1860s encompassed a general presumptive right to exemption from the incidental burdens of general laws. Now, finally, Kurt and Stephanie described the 14th Amendment as having incorporated the free exercise clause into the privileges or immunities clause. Now, all of us use incorporation as shorthand for the application of the Bill of Rights to the states, but we all should realize that this is really an anachronistic reading of modern positivism into a natural rights past. The framers of the 14th Amendment, like the framers of the original Bill of Rights, understood the bill to be declaratory. The text of the Bill of Rights declared, guaranteed, recognized, secured the rights it enumerated, but it did not create them. Incorporation also has a positivist resonance, referring to the text of the Bill of Rights having been incorporated against the states by the reference to liberty in the Due Process Clause. Mid-19th century lawyers understood the source of the enumerated rights quite differently. Michael Collins, Jason Mazzone, many others, including most recently Bode Campbell and Sachs, have demonstrated that the meaning of 14th Amendment privileges, immunities, liberty in the 1860s was supplied by the general law. Settled principles of jurisprudence common to free and civilized people, including natural rights, common law rights, principles of equity, the law of nations, and constitutional principles with a small c. It's only much later, after Erie, that the text emerges as the source of the rights enumerated by the bill. The free exercise of religion was included in the general law. Watson versus Jones, an 1872 case, held civil courts incompetent, that is, without jurisdiction to decide church property disputes by adjudicating theological questions. And I'm just going to quote a couple of sentences from the holding language. Quote, "The law knows no heresy and is committed to the sport of no dogma, the establishment of no sect. It belongs not to the civil power to enter into or review the proceedings of a spiritual court. The structure of our government has, for the preservation of civil liberty, rescued the temporal institutions from civil interference and secured religious liberty from the invasion of civil authority." Now, if those words had been written in 2024 or 1940, they would have just said, C, the free exercise clause, C, the establishment clause, but the court doesn't do that. It ranges through 13 decisions from 9 different states over 5 pages in the U.S. reports to show that the free exercise right and the anti-establishment principle that it was applying form part of the general law. Now, you can contrast this with Cantwell versus Connecticut, a 1940 decision in which Justice Roberts, for a unanimous court, applied the free exercise clause to the states in 3 crisp sentences, 2 of which merely paraphrased or quoted the constitutional text. I'm not going to read that language, but what's significant here is there's no laborious journey through decades of federal, state, and treatise authority. There's just a recitation of the text of the First Amendment of the religion clauses. The rule of recognition made the Supreme Court sovereign on this question, and Roberts had the votes. Now, one might suggest that you don't see the evidence for Kurt and Stephanie's thesis because Slaughterhouse so quickly slammed the door on applying enumerated rights to the states. But as I mentioned, Watson was decided a year before Slaughterhouse. And as part of the general law, the free exercise of religion was available to state courts as a source of law before the Civil War, in the 1860s, and even after Slaughterhouse. So if Kurt and Stephanie are right, there should be examples of state courts entertaining the proposition that a general law free exercise right excuse defendants from complying with generally applicable laws and incidentally burden their religious practices. They don't cite any. And here again, I'll go humble again. I don't know if any exist. I mean, I honestly don't. But this absence, I think, undercuts their thesis, even if we adjust it for general law from the First Amendment text. So Kurt and Stephanie conclude that their evidence permits a constitutional construction of free exercise that encompasses this presumptive right of exemption, even if their evidence doesn't compel it as an originalist interpretation. But I think the evidence in the paper doesn't allow even this more modest conclusion. It's always tricky to draw meaning from silence, but here I think the silence might be telling us a lot. The absence of evidence for their thesis in 3 places where one would expect to easily find it suggests that the free exercise right applied to the states by the 14th Amendment was understood not to encompass a presumptive right of exemption from general laws, and therefore would not permit this right even as a constructive understanding of free exercise. And now I really am done.
Thank you. Fred, thank you. So we're going to continue our debate over incorporation here to a certain degree. But I'll just say a couple of quick comments about that. But you challenge us on the evidence, and I think that's perfectly fair. However, you opened by saying something that, of course, is not silent at all. You opened with words openly declared by the man who wrote the Privileges or Immunities Clause, declaring exactly what the thesis of our article is. And you dismissed it because it came years later in 1871. As I recall, Watson v. Jones was also decided in 1871. So I'll tell you what, I'll give you Watson if you give me Bingham. In terms of relevance to constitutional understanding. I actually think that Watson is extremely important, and I've written about it before, not in terms of incorporation. I accept incorporation. I think the court has no interest in getting rid of incorporation, and I think the court is committed now to interpreting these clauses according to the understanding of free exercise at the time of ratification and adoption. That's why I think they'll be interested in this paper. So what makes Watson interesting is that declaration that the law knows no heresy, the establishment of no sect, that's absolutely crazy. Have you looked at any of the state laws, between the time of the founding and say about 1830, 1840? There's heresy all over the place. There's establishment of sects all over the place as the courts are awarding church property depending upon who was more closely adhering to the particular doctrine of that particular sect. What Watson v. Jones was announcing was that something had changed. A deepening, an understanding of a right against religious exemption. So it in itself is a signal that our understanding of individual liberties has changed. And that, of course, is part of what we're arguing here as well, that there was a deepening of free exercise rights, even as there was a deepening of freedom against religious establishments. In terms of the evidence that you're looking for, again, I think the framer of the clause, pretty good evidence, but you're saying he was speaking of a state law. Where's the evidence of the federal law? And a lot of my paper addresses that, and I guess we could have a discussion about whether or not you think the evidence is relevant. But most of the paper talks about religious resistance to the Federal Fugitive Slave Act. It also points out that states like Illinois and Kansas and some others were also passing their own fugitive slave acts, but most of the paper is about the Federal Act, resistance to the Federal Act, refusals of federal officials to enforce the Federal Act, juries nullifying convictions of people who were prosecuted under the Federal Act, and just general cultural encouragement of people in the North who opposed slavery to resist the Federal Act because it simply was an unreasonable intrusion upon the religious demands to care for the poor. Now, and I guess one last thing there, you also have a federal judge who, I think it was Greer, right, who's recognizing that there's a feeling in the land that there's a religious right to resist the Fugitive Slave Act, and he begins to instruct juries, don't you do that. I know you're thinking about it, don't you dare do that. It's simply indicative of this idea the freedom did exist in regard to both federal laws and state laws. So I think it is in play. I think an understanding of free exercises against both the federal government and the state government are in play and worked their way into general Republican understanding of individual liberty.
Thank you for these questions, Fred. I'll just add also briefly, I mean, it would be great if we could find more cases talking about this one way or the other. There's not a total dearth of cases. So, I mean, even just outside of the Fugitive Slave Act context, if we're thinking about early 19th century cases dealing with religious exercise exemptions, generally there are at least two, one in 1813 called People versus Phillips and one in the 1830s called Cronin, where the courts do grant religious exemptions to generally applicable laws. There are at least two cases that go the other way, but there the courts are sort of hostile or skeptical to the idea of judicial review, period. It's not that they're somehow uniquely skeptical to religious exemptions. And this is also a time period where judicial decisions just aren't regularly always recorded. So I think you're right, though, that it would be worth digging around there more to see if there's other interesting evidence to look at. And I agree with you that we are dealing with a declaratory approach to the right. There's a right that exists that is not created by positive law. This is something that Judd has written about as well. But one of the points that I also make in a separate article called Replacing Smith, at least about founding era understanding of religious exercise, and this is a point Michael McConnell and Doug Laycock and Judd and others have made, is that this pre-existing general law, right, if you will, to religious exercise was understood to have some limitations where government could limit it for important reasons. And the argument that I think is true at the founding and remains true in the Reconstruction period is that those reasons have to be pretty strong reasons, something like a law of necessity. And I think a doctrine like strict scrutiny is a permissible way to construct and to give meaning to that sort of understanding. And then the last point about polygamy, let me just say, I agree. We're planning to add a section to the article about this. So we have some research that we're still working on. So I appreciate you bringing this up. Polygamy is interesting. It's sort of a mixed bag. There's a range of laws, so you can't paint monolithically about it because it depends a little bit about which law we're dealing with respect to polygamy. But at least some of them, the first anti-polygamy law, the Moral Anti-Bigamy Act, and some others, there's some evidence that President Lincoln didn't think it was constitutional and there wasn't money that was allocated for enforcement of this act. So first of all, there's interesting debates and understandings about whether these laws are even sort of representative of public original meaning of what was constitutional under the Religious Exercise Clause and other provisions of the Constitution. Second is that when defenses of some of this legislation or government action limiting polygamy are raised, so far, they usually, at least our research so far, shows that they're coming up in two flavors. One is that they just deny that Mormons are a religion. You're sort of like, those people, that cult, so that we don't have to deal with the Religious Exercise Clause, because I think that demonstrates that they recognize that if Mormons had a real religion, like, we'd have a problem here. So let's just say that they're not. And then the second way that they deal with it is that they talk about ways in which polygamy is like slavery. Women are enslaved. So you actually see Harriet Beecher Stowe speaking out against polygamy just as she is against slavery. And they also talk about, harm to children, harm to society. Whether or not that's true is an interesting empirical question, and I'm not going to stand up here and defend polygamy. But I think the temperature of the rhetoric shows that people understood if we're going to limit religious exercise, and if that really is religious exercise, we better have a darn good reason for doing so on the level of harming children, enslaving women, things like that.
Assuming that Section 5 of the 14th Amendment provides Congress enforcement power over Section 1 and in a more expansive way than the court has currently viewed it, how would you see the relationship between, or the independent interpretive value of the historical evidence and interpretations y'all have proffered, and A, RFRA, B, a hypothetical statute that constitution, or provided for this absolute protection scheme that y'all seem to have rejected, and 3, a constitutional enactment that constitutionalized Smith, or a legislative enactment that enshrined Smith.
I enjoyed this paper. I want to raise a question about the Bingham quotation.
Sure.
And then a question, mostly about something that's in the neighborhood of Fred's larger concern. The thing that jumped out at me about the Bingham quotation was he could not have meant that the 14th Amendment is the thing that did the work of changing the legal status of the action that he was describing, giving the crust of bread, and so on and so forth. That would have been changed already by the 13th, right? That is to say, once the 13th Amendment is ratified, the problem that Bingham is dramatizing in this passage doesn't exist anymore at law, right? And that means to me, there are two possibilities, right? One that would be good for you and one that would be bad for you. I have no idea which it is. One is he's speaking imprecisely, rhetorically. It's a bunch of loose political talk extolling the Reconstruction amendments, and it might not tell us all that much about specific legal content, right? The other possibility, right, which you could exploit if you could cash it out, is he must be talking about exemption because he can't be talking about the presence or absence of slavery. In other words, he's imagining something that goes on even after slavery is done, right? It would be a hyper-technical reading, right, of him, right? And so I lean toward the first interpretation, but I see also the possibility of the second, so I want to offer it to you, right? My larger concern is very much like Fred's. It's like not everything that motivates the enactment of a constitutional provision is then part of the legal content of that provision. And abolitionists were upset about all sorts of things regarding slavery for many reasons, including sometimes for religious reasons. And this motivated a political movement, which did a bunch of things, including the Reconstruction Amendments. That doesn't yet tell me what the legal content of any particular thing that comes out of that is. To know that, I would want a lot more evidence about what people thought about free exercise in 1868 and later. And in particular, what I want to push you on is this. Do you have an account, if the evidence isn't robust, of why it's missing, right? Because the problem is in some ways parallel to the problem that has been pressed on originalists often about Brown, right? If the 14th Amendment, as a matter of original meaning, prohibits segregation in schools, why is it that for so many years nobody seemed to remember that? How do they all forget so quickly, right? And originalists have developed a set of answers, right, to these questions, some of which rely on the idea of principles that are incompletely understood at the time, and some of which rely on the idea of political failure, right? And the political failure story is easy to run because it's easy to think, well, yeah, there's a heady moment of idealism in the 1860s, but the forces that have racist views are simply too entrenched and too robust, right? When the high moment passes, that's just never going to happen. That story relies on there being a very strong body of opinion in the polity that really hates the idea that will ultimately be the Brown idea. And I'm not sure there's a parallel story to be told about like hatred of religious free exercise in the same way. So I wonder if something else substitutes for you. Like, what alternative story do you have for why there would have been a strong forgetting, a strong backing off of that commitment if that commitment is there and the evidence that Fred is looking for isn't forthcoming?
Great paper. I think you're making a really important contribution to what is about to be a very important decision of the court, and so I applaud that. When I first read the paper, I had Fred's first concern right away that, if what Bingham is saying is that before the 14th Amendment, the, free exercise was only enforceable against the federal government, and what this does is make it enforceable against the states. And then he uses this example, that would mean that the Fugitive Slave Act, there had to be religious exemptions to the federal Fugitive Slave Act, and this just extends them to the states. But where are we seeing the religious exemptions to the federal Fugitive Slave Act? But it all sort of came together to me when I realized what this paper is teaching me is that John Bingham was a non-originalist. That he, yes, maybe originally the understanding of the relationship between religion and government was one thing, and that was still, we saw that in the Fugitive Slave Act originally, but we've had a second great awakening. We've had a change in how we conceive of religion, a change in how we conceive of the relationship between, the religious obligations of an individual and the state and society. And now we're seeing that, as Kurt says, there's a deepening of free exercise rights at this time. There's we see this resistance building. And what Bingham is saying is the nature of, whether it's the natural law, right? We've now come to understand the natural law differently or general law differently, whether it's a positive law, right? It is, the scope of free exercise is broader and different than it was back in 1791, and that is the scope that applies not just in this 14th Amendment, but also to the federal government under the original one. So thank you for teaching me that John Bingham was a non-originalist. I'm proud.
Well, I'll start. Okay, I'll do a couple of quick things. Yeah, I think this is actually a conversation I've had with you, I think, about if they incorporate, if they actually apply this against the states, do they apply a new, more robust understanding, or even if they thought they're wrong, because if they incorporate it, they've just incorporated the original understanding. So I think John Bingham was very much a creature of ideas that had emerged between the time of the founding and the Civil War. I think his view of how this bound both states and the federal government were not originalist at all, but in fact reflected broad Republican theory regarding the meaning of the Bill of Rights. So I just accept that. I think that's right. Now I think of course, as people do in every revolution, they don't claim that they're creating something brand new. They claim that they are revolving. They're going back to the beginning. So he would have claimed that this was really the understanding from the beginning, and he did claim that the Bill of Rights should have been applicable against the states from the very beginning. I just accept that idea. In terms, Richard, I guess I'm kind of going in backwards order. Why do we not have evidence? We want to know what the people were thinking in 1868. My approach to originalism that I think really informs this historical part of the paper is that, of course, it's textualist, right? And so I've written about the meaning of privileges or immunities, and I believe that they understood the texts of the Bill of Rights to be among the privileges or immunities of citizens of the United States. And they held an understanding of those texts. They had an understanding of free exercise. They had an understanding of establishment. They viewed the Bill of Rights as a sacred document. They loved those texts. So in understanding the Privileges or Immunities Clause, I would want to know their understanding of those texts. And then so notice what the paper does. I go and look at definitions of religion and definitions of free exercise and show how those changed, right? From the time of the founding, from Samuel Johnson's to definitions you get during the Second Great Awakening and Webster's Second, and it's showing that in fact those words are changing their understanding. Then I talk about how people in the public talked about free exercise of religion in the period between the founding and the Civil War. So I think I am giving you information about the meaning of those words at the time of 1868. I don't think I need to have evidence of, and did they then have another fulsome discussion of free exercise during those years? I think that if I have evidence that there has been a broadly accepted understanding in play as of 1868, I think I've come some distance, right, in the originalist point. And then lastly, in terms of what might have happened to have generated a case, and why there are no cases, was it political failure like Brown? I'm trying to think about what might have happened. We have the polygamy cases, but our understanding of those, I think, are fairly characterized as either a denial that it was religion at all, or they understood they had to make really heightened scrutiny arguments to justify them. So I don't think the polygamy laws cut into our idea. So we must be talking about some type of federal attempt that would have abridged, that would have raised that kind of free exercise claim, and then a denial, and then a denial of it. And I'm just not exactly sure how that might have come up, and I'm not sure I see a failure. I just see an absence. So I would want to talk more. I'm not really resisting your point. I would like to find more stuff too, but I'm trying to think where to look, what exactly I'd be looking for. The congressional PowerPoint I just love, but I want to give that to Stephanie. Is it Ethan? Is that right? Yeah. That's a great point.
And just to also add to this discussion Kurt is having with you, Richard, I want to just also flag sort of the modesty of what we're arguing, which, at least with the article as it stands now and the research we've done so far, we're not claiming to have scorched the earth and found all the possible evidence that's relevant for any argument about religious exercise, but this evidence is consistent with the idea that a religious exemption regime was understood.
Right.
And it's certainly not consistent with Smith. So, and it's not just what Bingham says, it's the Promoli case that's dealing with, the yellow fever, and it's the 1813 and the 1830 case in New York and in Virginia. In all of those cases, if the rule was, well, as long as the law is neutral and generally applicable, that's a really easy thing to say to resolve those cases. And so whatever you think about the paucity of our evidence, there's far less evidence that supports Smith. Now, there's another option on the table that has been kicked around in terms of if we overruled Smith, maybe we should do something like Bruin for the religious exercise clause. We should say some sorts of religious exercise were protected if they were recognized, at the relevant time period. Others aren't. Some sorts of government regulations are okay. Others aren't. I think there's a lot of workability problems with that rule, but even bracketing those, I just think that that's a less accurate constitutional construction of the way that the natural law right to religious exercise was understood as being a right for people to exercise their religion subject to some important limitations by government. So anyway, I think that still it's worth looking harder at some of that evidence. And on the congressional point, I happen to think, Ethan, that Bernie was wrongly decided because Congress does have more power to, under Section 5, to do things like protecting religious exercise. That was a surprisingly judicially supremacist decision. We can talk more about that later, but I think that is an area where Congress has usurped, or the court has usurped some of Congress's power.
Just a quick interjection. Stephanie has a different theory of historical free exercise. Not different. We overlap to a certain degree, but Stephanie's work has, I think, dovetails with my understanding of Michael McConnell's view of free exercise, that we have failed to understand the robust nature of free exercise from the very time of the founding. My work has moved in the position of not at the founding, but I think it's developed by the time of the Civil War. So I want to separate that out. Sometimes
because I think Bingham was an originalist. So.
Okay, there you go. There you go. And so I don't want to overplay, even though I do have an idea about a growing and more robust understanding of free exercise. I've tried to be careful in the paper, and Stephanie's tried to help me be careful in the paper, to not resist the idea that this might have been there from the very beginning. But it certainly seems to be evidence of something that had emerged by the time of the Civil War.
Thank you. I really enjoyed the paper, and I had two questions. So one is on the burden of proof. I think you mentioned there's been some pushback on the strength of your evidence, and I think Stephanie mentioned that we have evidence that's consistent with our position. Just wondered, do you think that's enough if essentially what you're doing is asking the Supreme Court to overrule precedent in Smith? Is there a higher burden if you're asking for overruling a precedent? Second question, I was just curious to hear more about the scope of the free exercise right that you're asserting. I understand it to be not just the exercise of worship, but also of charitable acts. And how specifically or broadly do you define that? I think there's maybe a suggestion it wouldn't be kind of Bruin-esque or specific to only those types of religiously inspired charitable acts that were extant at the time, but do you have a more general definition of how you would kind of define the scope of that right?
I think I'll just pick up with that because both of you sort of answered my initial question, which was more about the history that isn't there, but I'd like to see more of. Maybe the distinction I'm looking for is along the lines of the scope of religious exercise, is the distinction between acts of charity as religious exercise, which I think you clearly emphasize here, versus acts of resistance to authority, resistance to law as religious exercise. And so here I'm thinking of maybe the history during the colonial revolutionary period of resistance to authority. I mean, you don't necessarily need to go back to the 1500s, but if you look at John Pinette and the Magdeburg Confession, they come up with this idea of the lesser magistrate doctrine to justify, as Christians, disobedience to authority. John Adams picks this up explicitly in his, I can never remember the full title, Defense of the Constitutions of the United States. So I'm just curious how much of that discourse about civil disobedience is relevant context for the kind of religiously motivated resistance, or as I like the title of Beecher's sermon, The Duty of Disobedience to Wicked Laws. And maybe this has some application, I think it's part 5 of the paper, maybe this has some purchase there. In terms of current law, by revealing how context-dependent this concept of neutrality really is.
Christine, I think it's a really interesting question about, should the court overrule Smith? What's the burden to ask court to do that? So I have views about that, but before I respond to that, let me just note that our paper isn't saying that the court definitely should. We're speaking to a court that has said, yeah, we're thinking hard about it. And if we do, what should we replace it with, right? So if we're speaking to an audience that they have decided this rule's a mess, it never had a historical justification, it's become unworkable, and it's just, fine work for lawyers, but not so great for litigants that just need a clear rule, and so what should we replace it with? That's who we're speaking to. Why do I think Smith probably ought to be overruled anyway, even though that's maybe beyond the scope of this paper, is, so if we go back to Reynolds, it's not as though Reynolds and Smith are completely simpatico. In Reynolds, the polygamy plaintiffs were asking the court to issue a rule that said, if our actions are based on religion, then we automatically get protection from government enforcement of laws. In other words, as long as our religion made us do it, we have categorical protection, full stop, and the Supreme Court was like, yeah, we can't do that. That would be courting anarchy, right? That's all that Reynolds really stands for. And then later, the court in Gedicks, where it forces the 11-year-old boy to salute the flag, that's really when you see the sort of Smith rhetoric from Frankfurter, this idea that we have to not make room for dissent in our country, we have to defer to political branches, and that's the court's job. And then in Barnett, the Supreme Court is like, actually the whole point of the Bill of Rights is the idea that we're gonna remove some protections from the vicissitudes of the majority. And that remains good law for freedom of speech. We still provide essentially what are exemptions, as applied challenges in the speech realm for compelled speech. It remained good law through Cantwell and Murdoch and Sherbert all the way up until Smith. And so Smith was really the interruption, became a test that hasn't been very workable. And you could see overruling that, going back to A, more originalist roots, B, the longer arc of precedent, and C, a more consistent sort of framework that is more on par with how we treat freedom of speech as applied exemption requests.
Just to address Andrew's question, and it's something that I've thought a lot about while I'm going through all these calls for disobedience, right? Disobedience against the law. I think one of the things that I saw is there were lots of reasons to disobey the Fugitive Slave Act, right? Not everyone was a religious abolitionist. There were secular reasons for resisting it as well. I think the religious abolitionists played a particularly important role, and I think their theories informed general Republican theory as well, so you have, when is civil disobedience justified? lots of different answers, but one of the answers they were given, that they were giving at the time, is that religion can provide one reason for justifying this type of prohibition on assisting runaway slaves. And why does religion provide an answer? Well, our Bible, that almost the entire nation knows about, that secularists know about, as well as Christians, Protestants, and Catholics, contains a specific command by Christ our Savior. And these weren't natural law theorists, right? I'm sure there were natural law theorists there. No, they were quoting the Bible that all of them knew as giving them instructions to not obey a law that required them to violate the command of the Savior. So it's one branch of civil disobedience that is justifying civil disobedience because of the importance of free exercise of religion that has to do with this fundamental command. And that's why I think at the end of the day, this shades into an understanding of free exercise as opposed to the general theory of civil disobedience. But I'm still thinking about that rule.
So thanks so much. I found this really interesting, and I don't know this area or this history well. Echoing other concerns, I would strongly urge you guys to put more state cases in here, especially because the opening talks about the First Amendment and is only looking at federal cases, but we know that there are a lot of state cases that are dealing with similar issues, if not this issue in particular. And the real question that I'd love to know the answer to is, was Bingham's position that this sort of was done by states, but in some sense was legally illegitimately done by states beforehand, a new thing with Bingham or with the 1850s and 60s, or was it an outgrowth of something that was there before? Because I think that for some people, differences in that, that history might make a difference to what they think was covered or not covered under the 14th Amendment. Thanks.
Fascinating, a very challenging paper. I am reminded of conversations I had with Kurt in the early 1990s about his paper, The Second Adoption of the Free Exercise Clause, which I think is a really foundational and extremely important paper on these topics. And just while I'm commending things, Stephanie's replacing Smith from 30 years later than Kurt's paper in the Yale Law Journal, it also has influenced my thinking about these matters. So I think you're underplaying your most important evidence in your response to questions. So what's really important here is the change in understanding of religion that accompanies the Second Awakening and its reflection in the linguistic practice. You have evidence of that in the form of definitions, right? So religion is godliness or real piety in practice, consisting in the performance of all known duties to God, and then echoed in Bouvier's dictionary. That's the really important evidence here, because we are talking about the public meaning of the Privileges or Immunities Clause in light of the understanding, publicly shared understanding, that it incorporates the provisions of the Bill of Rights, including the Free Exercise Clause. So, but the question I have is about the radicalness of your evidence, right? So your argument is not limited. The evidence you provide is not limited to a duty of charity, right? That would be an example of the duties owed to God. But this new understanding of this altered understanding, maybe not altered, Stephanie, but this understanding of religion means that all duties to God, right, in practice are exercise of religion. And free exercise of religion would extend to all of them. So that's quite radical. So, as I sort of see this, the Barclay-Lash program working out, we get a two-part test. Part one, we ask whether or not this is exercise of religion, right? Understanding religion in this way, in this sort of second awakening way. And then step two is strict scrutiny, or something like strict scrutiny. So I think the problem is not going to be about step two. We all know how to do strict scrutiny. We all know the problems with strict scrutiny. That part is very familiar. The problems are all going to be at step one, right? And so I just want to suggest sort of two different approaches to step one. So one approach is that judges would answer the question, what are our known duties to God, right? That judges would independently inquire into what we owe God. So I think judges are very reluctant to do that for a lot of reasons, including modern pluralism. So what's the alternative? The alternative would be that judges don't answer this question independently, that judges would look to religious practice on the ground in order to answer this question. So, and they could do that in two different ways. So the static conception of duties to God would be that what we would look to is the duties to God as they were recognized as of 1868, right? And that would have certain advantages, right? Especially to a court that's very focused on history and tradition. And it also would mean that we would not get to a set of problems that would attend a dynamic understanding of the of sort of duties to God in practice, how duties to God are understood, right, by various religions. And the obvious difficulty with this dynamic approach that would recognize changing duties to God is that given sort of contemporary religious pluralism, there's going to be a lot of them. And they're going to be wildly different from each other. And we're just going to run into administrability problems. So I just would ask you to say a little bit about Barclay-Lash step one, the identification of those practices that count as duties to God.
And I have two friendly points and then a question building on Larry's. One, the Bingham speech is amazing. And for people who have just read it for the paper, I do encourage you to go read the whole thing. There is this problem. This is one of the weirdest Bingham speeches that in the 14th Amendment Privileges and Immunities literature is debated about whether this is, consistent with things Bingham had ever said before and what's going on here. But the thing is, Kurt already has 50 pages of defense of why this Bingham speech is the correct understanding of the Privileges and Immunities Clause, which I urge you to just go ahead and full-threadedly incorporate here. Because then you can say, as you've sort of said to us, look, if you accept anything about Kurt's views about the Privileges and Immunities Clause, which many people do, then you accept the Bingham speech is like the proof text for the whole thing, and so it makes sense to go look at it. And if you don't, that's another fight. We can talk about, but so in that sense, the Bingham speech is great. One thing that's point one. Point two, the Bingham speech, when I read it, it's interesting. It has a second example after the crust of bread and after the citation to, in the Globe, they even cite the Moore case. The second example Bingham gives is Georgia sending men to the penitentiary for teaching the Indian to read the lessons of the New Testament. And I didn't see that in here, and I think it might be nice to bring that in as well. It's just an interesting example. It doesn't have the 13th Amendment issues. People will say it's sort of a speech issue, an additional religion issue, but in any case, it seems like that's another instance of religious aid that's protected, and it's, just, and
It's a great
who knows?
point.
There might be lots more to say about why that example's in there. But then the puzzle I have is a little bit of Larry's puzzle, what to make of the crust of bread story. Because the thing is, that and all the examples in the paper are examples of people whose religious beliefs are true from the point of view of the speaker. They're following the correct religion, disobeying a law that is bad. So that seems the easiest case. It's like you are following the actual commands of God as against an unjust law. On the other hand, Reynolds is an example of people whose religious beliefs, according to the speaker, the court, are false, disobeying a law that is good. And so that's not protected. And that makes me worry that that's the way they would operationalize this test is, well, if you're following actual God and disobeying bad laws, that's protected by the Constitution. And you're following some false God and disobeying good laws, that's not protected by the Constitution. That seems like it would be a very difficult rule to operationalize today for multiple reasons. But that's our problem, not their problem. So it makes me worry that we're going to find something actually very uncomfortable here that doesn't do a good job of replacing Smith.
You want to go? You want me to?
I feel like accepting all these are very, very helpful. Stephen, we need more state cases. Yes, I want more evidence, and we're continuing to dig. My I loved your question about Bingham. Was he saying it was unconstitutional at the time, or that something now has changed with the 14th Amendment? That's a complicated question just in terms of Bingham's theory of the Constitution. I think he would say something like this: it was unconstitutional, it was in violation of the Constitution when it occurred, but we had no means to enforce it before now. And that's how he described the big change in the 14th Amendment, that now we were announcing that these were national privileges or immunities, and we were adding a Section 5 to get there. Larry, man, we're going to be discussing exactly how to grapple with step one. I appreciate your point about the linguistic evidence, and I want to make sure. I was very excited actually when I actually saw the evolution in definitions in dictionaries, and then saw that dictionary reference quoted in the Congressional Globe in James Wilson's speech, talking about the importance of free exercise of religion, and they put the definition in quotes. The writer, the transcriber of the Congressional Globe, recognized that he was giving a specific dictionary definition of duties to God and God's instructions for fellow men. So I do think it's an important point for an originalist exercise, and I'm going to try not to bury it. As for what we do about step one, Stephanie, you got to help me here. It's a hugely important question.
I think you're right, Larry, that we need to wrestle with that more. This also goes to Will's question. Like, is step one, if we took the static approach, is the static approach that we protect religious beliefs that were correct at the time, widely accepted, and only disobeying like really bad laws? That would be like a historical analog that we can protect. That'd be a really awful rule, right? I think that, so I think it's hard. I do think, at least at the founding era, some of the cases that are grappling with something like step one, they look at the fact that this person did have a sincere religious belief, it's a sacrament or some other sort of conviction that is important to them. And the courts or other government officials who discuss that don't seem to make a big deal over whether it's right or wrong. Now, granted, at the time, certainly a lot of these religious beliefs were the prevailing view, but we have President Washington's letter to Jews, where he's talking about how important it is that we make every accommodation for religious belief, clearly to a sect that he doesn't agree with, which I think is one example, and there's more we could point to that point to a more dynamic approach, at least towards whose religion gets to come in under the camp of step one. And I think We should probably maybe be cautious about how much we're referring to religious acts of charity, because we don't think doctrinally it would be limited to acts of charity. That happened to be what they were focusing about. It's a particular application, but to Larry's point and Will's point, it's just a religious exercise that happens to be about charity in this case. So I think we should be more sensitive about that and do more work, both into the doctrinal section and the historical evidence section, to grapple with this question.
And quickly, Will, your point about that second part, or the final part of Bingham's speech,
Yeah, good point.
you're right. It's one that I actually had emphasized in my original article, 30 years ago, and your instinct is correct. I didn't include it this time because it shades into freedom of speech, but I should remind myself that that isn't how they viewed it. That might be how it would work out today in terms of jurisprudence, but at the time, that was understood. The duty to teach to people how to read was part of your religious duty, so that then you could share the gospel and teach them how to read the Bible. So they discussed it. They specifically discussed it that way, as a violation of religious duty to prevent teaching Black Americans. And it's interesting. Notice how he's broadening everything. He doesn't say teaching enslaved people how to read. He talks about teaching Indians how to read. He doesn't talk about Southern slave laws. He talks about Northern fugitive slave laws. He's giving a very expansive interpretation here, and that simply helps our case. So thank you. You're right.
Thanks to everybody, and thanks a lot to Mike for organizing this.